So welcome, ladies and gentlemen, to tonight's Dean's Talk. Thanks so much for finding your way to University of Graz's pop-up store here in downtown Graz, a lovely location that we have rented for a couple of weeks only, based on an initiative by the rector, which is very commendable, of course, in order to share the wisdom of this wonderful institution and spread the gospel for all those who can't find their way to campus a bit uptown. It is my distinct privilege to welcome Professor Adam Scales from Rutgers University School of Law here at our Dean's Talk tonight, and to University of Graz School of Law in general. And Adam, it is great to have you. Thanks so much for being with us. So, Adam is a professor with a unique portfolio, at least if you were to compare it with Austrian standards. Adam teaches torts, Adam teaches procedure, Adam also in particular teaches administrative law. He's a visiting professor at University of Graz School of Law at this term, teaching an introduction into US torts. However, tonight we're going to cover a quite different topic, because Adam, if I were to start our debate in the following manner, there is rumor at the faculty that you're here not actually as a visiting professor, but as somebody who would apply for political asylum simply because the situation in the US has become so messy at the moment, in particular when it comes to US constitutional law and where it's heading. Is that correct, or is it an unsubstantiated rumor?
One must always keep one's options open. However, I have no plans at the present time to apply for asylum. It is true that the situation in the U.S. Politically is fraught. I mean, I'm sure that you read about this in your newspapers here, and imagine having to basically live it on Facebook and faculty meetings and virtually every aspect of life. That said, as a frustrating and challenging as it frequently is, I don't envision too many immediate plans for people to flee the country.
Okay, good. That's good to hear. It's good for the US, of course, to hear. But to be quite frank, what is going on at the moment? What is going on in particular at the Supreme Court? I mean, the Supreme Court is a court that has been held in very high esteem, not only by American citizens, but had a role model function all over the globe, basically, for at least the past... oh, your mic seems to be off. Okay, for at least the past 100 years, and it seems to have become an institution in turmoil. Draft opinions are being leaked, investigations are going on to be conducted by the courts martial, etc., etc. That's not the normal state of affairs, one may say. How did it come to this, and where does the road lead, in your opinion?
Like many things, it is gradually, then all at once. How can I begin? Institutions worldwide, but absolutely in the United States, have found themselves being undone in recent decades by Islam. And you would think that the Supreme Court, being an extremely staid and conservative place, would be immune from some of these challenges, but no place is immune. If you think about the legitimacy of the court, which rests on public respect and acceptance of its rulings, this has worked well for quite a period of time, but in recent years, everyone, not everyone, but in the different segments in society have wanted to take pot shots at this report. So, when I was growing up, the frequent critics of this court would be on the conservative side. They would criticize rulings by the court that expanded criminal rights, or certainly constitutionalized right to abortion, or otherwise appeared to be activist. In recent years, the criticism has largely come from the other side, as a more conservative court has retrenched or certainly reversed some of its earlier holdings. But the vitriol is, in my estimation, greatly magnified in the past few years. So to take a case that probably, I don't know how important this case strikes people outside the United States, but the Citizens United case, which was a case from 10 years ago, in which, in conjunction with a second case that never gets the same attention, the Supreme Court recognized that corporations had rights to participate in the political process. They had First Amendment rights. Well, legally, this is not the most controversial thing. It's a joke that's made. Corporations are people too, but this has been true in the United States since the late 18th century. So this is not good. Nevertheless, it stripped away certain conventions or ambiguities and created a very big target for critics on the left to say that the Supreme Court was now being bought and paid for by corporations. Now, I don't have to agree with that. Citizens United is absolutely correct. However, I want to point out that few institutions can survive a constant assault, whether it's from left or right. And so, over a period of decades, from different directions, the Supreme Court's legitimacy sounds too dramatic, but like a plane flying through the air, you can lose one or two bolts at a time, but it's probably not a good idea. And this has been happening at the Supreme Court as people have wanted to see it in partisan terms because that's convenient for their ideological perspective. Very true on the conservative side, looking at those activist judges, and now demonstrably true on the left liberal side. All of the conservative judges, they're just politicians and bros. Everybody seems to want to criticize the Supreme Court for being politicians and bros, just not our politicians, appears to be the logic. That has brought matters to a point where the Congress and the President have occasionally made noises about expanding the court avowedly to put liberal justices on them to counteract the run of conservative justices. They thought about some other measures to try to cabin the powers of the Supreme Court. These are not very popular across the country. They failed spectacularly about 90 years ago when Franklin Delano Roosevelt tried the same thing. But to activists, this is an appealing target. And that means that the court, for some time, has had to navigate the politics of its own existence and composition in a way that has not been true for decades.
Well, let's rewind a bit. So you were referring to politicians in robes, and evidently this is a court that heavily deals in politics. I mean, it's a Supreme Court. It's not merely a constitutional court, according to the Austrian model, for example. So it deals with questions of private law, just as it deals with questions of criminal law. However, these are hardly ever in the spotlight. In the spotlight, of course, are first and foremost the questions of constitutional law, simply because these are those of the gravest importance for the polity as such, what could emphasize. And so the impression of the casual observer would be, of course, this is a court that decides, and necessarily so, political questions based on the Constitution, whatever that should mean. We can go into that later on. However, the way the court is composed and the actual membership in the court has become, or so at least the observer would reckon, an outright political war zone. I mean, confirmation hearings to the U.S. Supreme Court have become an outright mess. If you, the two of us, when I was visiting Rutgers in 2018, two of us observed the Kavanaugh hearings, which were, well, interesting, to put it mildly. They were a public spectacle, basically. Neil Gorsuch was was perceived by many on the liberal side of the political spectrum, a very problematic candidate, such as was Trump's third nominee, even though the first and the third nomination sailed through quite smoothly, even though by very narrow margins drawn along political lines. The same now basically applies to Joe Biden's first nominee. She was confirmed in the Senate, but overwhelmingly only by Democratic votes, many Republicans being able to consent to her nomination eventually. So it has become a very partisan institution when it comes to the nomination process. Therefore, judges are perceived more and more as outright political actors in the political arena, with all the damage that is done to these persons themselves, evidently, and to the court as such. And that seems a rather recent development. Is it a recent development that mirrors American politics in general?
Yes. You can trace that for most of the court's history, confirmations were relatively sedate affairs. Of course, there were nominees who failed to advance, usually because of questions about competence rather than questions about ideology. But one could date the emergence of the modern confirmation battle to the failed nomination of Robert Bork in the 1980s. He was a staunchly conservative fellow and very extremely well qualified, and he basically bequeathed a modern understanding of antitrust, which hasn't been undone yet. He's a very influential jurist. That fight was bloody, principally because he was opposed to Roe v. Wade, as well as predecessor cases that made him very unpopular in some circles. Since then, the norms of civility sounds so motive. The norms of deference to presidential selections, a norm of at least being able to pretend that the nominee of another party is not your mortal enemy. These norms have eroded. I think Ginsburg, who she'd been president of the ACLU, there was no question where Ruth Ginsburg stood on any issue of importance to conservatives. Her confirmation, I think it was 96-0 or 96-3 perhaps. That was only a quarter century ago. But now, of course, confirmation votes reflect within a vote or two the partisan composition of the Senate. There is a sense in which this can be defended if recognized as unpleasant. So we had this discussion, but I was talking recently about the number of elected judges in the United States. That is, at the state court level, many thousands of judges are elected. They are not appointed in the way that we see the Supreme Court justice appointed. Okay, so there are many things to think about this. But once you have a system in which the judges are elected, it seems a little odd to expect people not to vote their interests. So if you think that this judge candidate is going to be soft on crime, maybe you did not like the sentence he handed down. As a voter, I suppose you could be extremely other-regarding or something and say, well, even though I personally don't feel that, I recognize he's a good judge. No, you're going to go vote for the person or against the person. He does not appear to align with your interests. as the Supreme Court has been called upon to engage ever more directly with American-led politics, it has become, and as our country has become more polarized, lacking a shared vision, not just of the judiciary, but seemingly of anything. It is hardly a surprise that senators have started acting like political actors rather than rubber stamping the nominations of judges from other parties. I can't say that I like this because, for reasons that we'll probably get into quite soon, these confirmation battles are getting extremely tiring. And they inevitably do damage to the courts because, like any institution, the court needs a veneer. It needs a belief in, if not its infallibility, in its separation from politics, from worldly matters. The vision of a court that is attuned to the requirements of the Constitution is an extremely appealing one within American political and civic norms. And so I don't think that people want to think of the court as just a bunch of politicians. I don't think that the court does consist of a bunch of politicians, although, and if they're making decisions, of course, I can kind of predict, as could you, where many justices will come out on many issues. But the process of nomination and confirmation, with its seemingly catastrophic stakes at all times, has been one that has not brought credit to the Supreme Court or to the Congress. It's not that the nominees are doing anything wrong. Basically, a confirmation testimony these days consists of the senators pretending not to ask the nominee what the nominee thinks about Roe v. Wade and a few other cases, and for the nominee to pretend not to be answering that question. This is a seemingly intolerable fiction, but one of the results is that when senators decide, well, I think this person is on my team, or I think this person is not on my team, they vote accordingly. And without regard to a norm that might be thought to elevate senators from grubby politics and say, well, I'm supposed to be doing what's best for the institution of the Supreme Court, and that might mean I have to vote for someone that I don't really like, but recognizing the person's qualified. That political norm is at the moment dead, and I think that's very unfortunate.
And interestingly so, because I mean, you mentioned the important cases that the court hands down, and some of them landmark decisions about to be reversed. We're going to get into that later, evidently. However, if you look at the really, really important Supreme Court cases, landmark judgments such as Brown versus Board, Roe versus Wade, New York Times versus Sullivan, and so on and so forth. So from various parts of the U.S. Constitution. I mean, they happened decades ago in a time where it was by far not as or wasn't concerned as bad or as bloody a battlefield as it is today. These decisions were eminently political decisions, even though, of course, as you indicated as much, the nominees to the court would always, of course, refute that. They would say, well, people from different ends of the political spectrum would agree on that, at least during their nomination proceedings. Elena Kagan said, well, no, what we're applying is law all the way down. This is not political questions that we're dealing here with. The current Chief Justice famously said during his confirmation hearings, well, what we do is we're calling strikes and balls. That's not something that has to do with politics. Of course it has to do with politics, and it always has. Lawrence Tribe, in one of the recent New York Reviews of Books editions, outright ridiculed Stephen Breyer's latest book on the power of the court and the peril of politics, because he called it simply too naive to still make the stand that the court is not eminently a political actor, and the judges of the court are not eminently political actors. Wouldn't it be better given the situation, to perhaps approach this a bit more realistically, a bit more truthfully? And wouldn't the court gain credibility if its members gave up their position on not being political actors?
I think that the argument from self-interest that the Supreme Court ought to emulate the other branches has limited appeal. It would be difficult. Probably the only institution that is less well regarded by the American public than Congress would be the media. And so I do not think it is a winning strategy for the Supreme Court to attempt to emulate Congress in the sense that you mean, of course, there would be some other differences, but you're not wrong, as I said earlier, about the element of fiction here. I don't know. I think when I was younger, I probably was always in favor of being extremely transparent about reasoning and making premises clear so that we can talk about those. And I hope that I do this in my personal and intellectual affairs. But as I get older and observe institutions and how they actually work, nobody is direct about anything. There are too many costs to directness and candor. And one might question whether there is a certain wisdom in that. That is, younger me, things will certainly work better if everyone's quite clear about where they stand. I'd like to believe that, but I feel that time has worked its will on that particular impression I once had. With respect to how the justices might comport themselves, it is very easy. This is true even in a domestic context. I think even easier for those who observe it in the court from afar, to not notice, one, how much consensus there is on cases that are sufficiently controversial that they still get to the Supreme Court, but also how complex and open textured the positions of many of the justices are. That is, if I were to say to you, my daughter has considered views on the nomination process.
Strong opinions.
Yes.
Just like the phone.
She might be replacing me here momentarily. We'll see.
So she's free to do so.
It might be an improvement. Who can say? So, as noted, I teach a course on American liability law, torts. And one of the questions that the Supreme Court has returned to several times over the past 25, 30 years has been the extent to which the federal Constitution can displace the tort law of a state with respect to exemplary damages, punitive damages. Probably not something that happens here, but we like occasionally to hand out a punishment with respect to a tort claim to set an example, make sure the defendant never does it again. So if there are $10,000 in injuries, we give the $10,000, but in the right case, we might give another $10,000 in punishment damages.
Okay, million.
And there's an $8 billion verdict in my hometown is Johnson & Johnson, which got reversed like most of the $8 billion verdicts. But the fact that they exist is certainly noteworthy. If you were to ask yourselves, well, reflecting on the composition of the court, thinking about the perhaps necessity of transparently revealing or stating the justice's preference as political actors, who do I think would be in favor of taking the rights out of the hands of tort claimants and basically putting rights in the hands of big corporate defendants? Because that's who was complaining about large tort awards, of big corporate defendants. You might predict that the liberal justices would absolutely be against helping out the companies, and that the conservative justices, who could not possibly care about individual rights, would be the ones insisting that the federal Constitution limit punitive damages. No, Justice Breyer was a big fan of federal constitutional control of damages. You know who opposed that? Justices Thomas and Scalia, who were also the most criminal defendant-friendly justices on the Supreme Court during their time. I think they would not be forewarned, but in the context of the past 20 years, it was Justice Scalia and Justice Thomas who often, particularly Scalia more consistently, who very often said the criminal defendant should have more rights here than other justices want to recognize. There are many, many rulings, of course, in which Justice Scalia and Justice Thomas and the justices you mentioned who recently appointed, of course, are espousing the views that I would predict, knowing them and having read their opinions. But I have to tell you, I don't think I would get such texture from a conventional elected politician who generally picks a side and sticks with it. And this underlines for me the fact that while clearly there are politics in the process of nomination and confirmation, and absolutely there is a thing called ideology, it does not always map on to the understandings of democratic politics. And it would be a mistake, and remains a mistake in my view, for the many contemporary critics of the Supreme Court to just assume the only possible explanation for the Supreme Court ruling against me is that they are Republicans in black votes, and it is just like the Senate or the House. To me, that is a blinkered view. It does not grasp the complexity of things. Doesn't mean that they're not entitled to disagree quite strongly with these rulings. And again, of course, there's ideology that plays a role in the judge's understanding of his or her function, his or her method, and yes, perhaps even the satisfaction one takes in the result at the end of the day. But no, it is not a conventional political process, and I do not think that.
I mean, many would argue that, of course, it is not only an ideological question, it is also a question of, let's say, the jurisprudential approach of the respective justices, and those approaches vary vastly from originalism, whatever that may be, because there's evidently different strands of that school of thought, to living constitutionalism, whatever that may be, because there's evidently different strands of that school of thought. However, critics then again would argue, well, this is basically just cloaked ideology and would support certain preferences of certain individuals who have strong political opinions and leanings. To what extent is the Constitution itself to be blamed for that? Simply because, I mean, it's a rather impossible document that you have here. If you look at the Austrian Constitution, the Austrian Constitution is one of the flexible constitutions, as our federal president has recently emphasized. It is elegant and it is beautiful. Yeah.
I did get that joke.
Yeah, it is neither, as I try to explain to my students. However, it works, and whatever works is just fine. First and foremost, it is very long. Nobody knows exactly how long, but it's very long. So the materials that we will hand to our students would be well, textbook length of constitutional provisions and statutes that would be closely connected to those constitutional provisions. And so it is very detail-oriented, which in and by itself speaks against its beauty and elegance. However, that mustn't matter too much. Whereas the American Constitution, it may really be beautiful in some parts, it may really be elegant in other parts, it is highly problematic in the third parts. It is short in any case. It has been amended 27 times overall. That is simply because it is impossible to be amended virtually, at least nowadays, because you couldn't find the consensus necessary. And so you have to deal with a document that is very, very old. It is very, very vague. It is very, very short, and it gives great leeway to those who actually are in the position to say what the law is. Is the Constitution in itself granting too much power to a Supreme Court? And is that something that the US should work on in order to overcome the difficulties and play it back to the political arena?
I detect
independent note of personal blame with respect to the American Constitution. I didn't write it myself.
You're one of 3 Americans in the room.
Well, my daughter will be happy to take up the defense of the Constitution. One of the first things I taught her. So, the particular role of the Supreme Court was established relatively early on. I mean, it was not set in stone just based on the text of the Constitution that we have the Supreme Court that we do. By that, I mean one which twice a year validates laws by Congress, and certainly has, we've talked about Brown versus Board of Education, that's the great desegregation decision 70 years ago now. Has such a central role in American life. One could read the Constitution and the very short third article, and there's no way the Supreme Court is going to be running this place 200 years from now. And the fact is that it developed its power and influence one case at a time. This is a form of political capital, so in that sense, without doubt, the court is a political organization. With respect to the elegance or lack thereof of the Constitution, as I teach administrative law, which is how the federal government goes about its business, and that is grounded in constitutional law, separating powers and things like that. It's amazing how much the Constitution leaves unspecified. I mean, very simple questions. How is X to happen? Can you fire a Secretary of the Treasury? You think we have an answer to that? But we develop answers to that by convention over time. And so what it lacks in a priori specificity, it has earned through the actual experience of government. And this, I think, can be regarded as a strength. Yes, it would be nice to have conclusive answers about many things. Seemingly an impossible task. I don't know, and forgive me, when the Austrian Constitution was written, but our Constitution.
It was enacted in the beautiful year 1920.
Okay.
Yeah.
I mean, while.
And then it had, solid 14 years going for it, basically, and then, events. And then, it came back to life in the second half of the 20th century as well, which is why we now act as if it is 100 years old.
The 1920s, as far removed as they are, practically around the corner compared to the world of 1789. I can't imagine that a constitution written in 1789 would anticipate all the questions. I don't care how long they worked on it. It could not possibly have anticipated all the questions of today. That itself creates interesting interpretive challenges. The living constitutional side would say, well, that's exactly why we need to be expansive in our readings of it, because they didn't know that the internet was happening. And so we need to make sure that we adopt readings that are in tune with not just technology, but contemporary mores. Justice Scalia used to begin talks by saying, "I come in praise of a dead constitution." And this might seem, rather backwards. Who could be against progress? Who could be against development? But for originalists, the appeal of focusing on the text of the Constitution as it would have been understood allows a starting point to determine what questions are answered by that document and that process, and which questions must be answered by some other process. So there's if you are constantly able to discern within the Constitution whatever could be individual rights, it could be structural issues, if it can constantly adapt to new circumstances, even apart from the very serious risk that some people might get the idea that this is happening according to a partisan process, even apart from that, you are enervating the other branches of government because you're not giving them a chance to do their jobs and to be held accountable by the people. Because I can't vote the justices off the Supreme Court. They're there for life. I don't think this will change, although there are rumors about changing it. But even if that were to change, I still would not be able to vote for them. I can vote someone into or out of Congress, or into and out of the White House, who adopts a regulatory philosophy I don't like. That to me is appropriate. And if you agree that there is virtue in the ability of the polity to channel its preferences in the form of elections, elections which will not be available in the context of the Supreme Court, then you should think carefully about whether you actually want the Supreme Court to reach into the domain of those branches, whether it's living constitutionalism or something else.
Mm-hmm. So basically, the setup of the Constitution, the way it is handled, we can say, doesn't seem to be the gravest problem, or so at least I take it from you. I was wondering, to what extent does the common law tradition of your country come in handy when it comes to that? This is civil law country here. We like our laws written. We like our laws specific. We like our laws somewhat exact, or so we say, simply because then we can at least somewhat honestly, speak of us as lawyers who indeed do apply the law all the way down and call balls and strikes because our rules are that exact. I mean, it's a bogus case that I'm making here, because in the end it might work just the same. However, the leeway granted to those applying the law, to those saying what the law is considerably smaller than, of course, in a common law tradition where the judge has the self-understanding to legislate in the first place. So does a shorter, a vaguer constitution make more sense in a common law tradition from the very outset than a very specific, very long constitution that arises against the backdrop of a civil law tradition such as here in Austria? Or is that simply the question wrongly put?
It is an elegant question. I do think that the common law experience and mindset would certainly give a constitution drafter some confidence that the process of iteration would tend to work things out over time, and that it was not necessary to specify everything at once. But what role this hypothetical insight actually played is something I cannot answer. About 10 years ago, I started teaching administrative law, and most of the cases, half the cases are Supreme Court cases, and the rest are cases decided by federal courts. Now, my first set of fields involved torts and insurance law, which is, in the American context, a blend of contract and torts. Very common law. My students, my entire career, I'm sure are united in their hope that there must be some rules somewhere, that every case in torts appears to be new. The answer could be this, it could be that, nothing is really right, nothing is really wrong. Wouldn't it be nice to have more precision? Now, I've argued against this in many contexts, but even I thought there might be some truth to it. And so when I started teaching administrative law, based on the federal constitution, statutes, and regulations of agencies, I was certain I would find a more deterministic process. After all, the Supreme Court is not really a common law court. We would not call it that in the United States. And I thought, okay, there are going to be some answers here. Not a single one. I'm telling you that if you think that American tort law, with its hot copy lawsuits and exploding Pintos and everything else, is hard to predict. Just try reading 10 different Supreme Court opinions on the Administrative Procedure Act. They are all over the map. They've got the different views of the justices. Very often they kind of find a way to work together well enough to give enough guidance to get this one case decided. But, and Breyer is the worst offender here, you try to figure out what they're really saying, it is a mystery. In some sense, this is reassuring, because your kind words about the Austrian civil law notwithstanding, it has persuaded me that there is no magic alternative to a process of slow, grinding iteration. That process might be disguised or take different forms, but it is there nonetheless, at least with respect to the area of American law. And so also could be a system which this works differently. There appears to be no alternative. And so, I can return with renewed confidence to the fact-smothered morass of my main field of torts, because really, the grass is not greener on the other side.
Okay. That's good to hear, certainly. I would like to remind the audience that you're free to join the discussion at any time. Simply raise your hands, and Adam will answer any questions he likes and not answer the question he doesn't like. That's basically what we had as a common understanding from the very outset. I was handed already a question by one member of the audience. I shall ask you later. And before coming to that.
Oh, I look forward to it.
Yes, you should, and you need to answer that one, truthfully. Before we come to that, I mean, you indicated as much that evidently a court or courts in general that do this grinding, as you referred to it, and develop the law case by case, basically. They make it not necessarily easier, you refer to administrative law, to be approached, to be understood, and to be acted upon, simply because there's so many things you would have to take into account at once. So many different positions, minority positions that may become majority positions one day, and nuanced arguments that may not make a difference today, however, may make a great difference tomorrow. And that is something rather alien to the Austrian mind. It is, or it has been always a great surprise for me to find out that even the practice of the Supreme Court handing down court opinions, or at least majority opinions, has not been self-understood from the very outset. It was only John Marshall who introduced the practice, if my received wisdom doesn't serve me ill here. That is, and prior to that, the justices simply wrote their own opinions to the respective cases, and you had to add them up, basically, to find out what the law is. To find out what the law is still is very complex against the backdrop, as we sketched it rather here. Whereas in Austria, and this is a discussion we're having at the moment, the Supreme Court, the Supreme Administrative Court, or the Austrian Constitutional Court, they simply hand down, just like the European Court of Justice, court decisions and opinions. So there would be no separate opinions, at least not any separate opinions that would be out there in the open for the public to discuss and to scrutinize. And minorities in the court would have to do their own grinding inside the court in order to evolve into majorities. However, they would lack any public support, say, well, okay, we know that as of now this was a 5-4 decision, or translated into the Austrian Constitutional Court's composition, this was a 6-7 decision, and maybe next time when this justice leaves, the decision will turn out in a different way. So in Austria we have this huge discussion whether or not we should actually introduce separate votes and opinions to be out there in the open, on display for the public to scrutinize or discuss. what would your recommendation to the Austrian legislator be? At the moment, there's a proposal out there who would suggest that the Constitutional Court Act should be amended in this direction, that such separate opinions, that means the concurring or dissenting opinions, would actually be a possibility in the future. Would you recommend that we should introduce this possibility, or would you say, guys, you're rather well off as you are, don't mess with the system?
So, if you were starting a system from scratch, I think one way that you might approach that question is to ask, what level of dynamism does the system require for it to meet my objectives? I mean, clearly, law is inherently conservative. You can't change opinion every day. But when I think about the tectonic changes in constitutional law over the past century, American constitutional law over the past century, I certainly feel that if I had to choose a process, I would not choose one that might foreclose that. And it was very interesting listening to your description of how things work here. I think that if you allow minority opinions, you can get a clearer ventilation of the actual issues over time. You made this point at the beginning of your comments, maybe a minority opinion, a dissent, maybe a footnote, takes on importance over time.
Footnote 4.
Footnote 4. Caroline products. Don't waste your time reading that case. The benefit of this is that the dissent can lay markers for future justices to consider. They can appreciate, yes, you know what? The court really did engage with this issue, and they didn't see it my way, or they resolved the issue. We don't really need to go back and fix this. Whereas, if the controversies are shrouded in a bland opinion, which we actually have in the Supreme Court, they're called per curiam decisions. They're often written by Justice Roberts, who's an outstanding writer, and certainly knows how to cover up things. By which I mean, he knows how to conceal the number of disagreements that might have reluctantly led justices to acquiesce to a particular ruling. And he would do this saying, look, we just don't need to stir this up right now. We need to resolve this case and move on. Clearly, that option should always be available. And Roberts has probably done this more than any of the chief justices I can think of in the past century. That said, I do fear that if you did not permit the expression of the dissenting views and make that a regular part of the process, that you might end up hamstringing needed development of the law, because certain problems that really might require rectification would be submerged under a veneer of unanimity. I mean, I certainly could not say that there's a single approach that's right for everything, but it does strike me that this would be a cost of the approach that Austria is currently taking.
Mm-hmm. Well, I mean, the counter-argument evidently is introducing separate votes, or the possibility to make use of that, and thus concurring or dissenting opinions even, would further politicize the court. Just as the U.S. Supreme Court, the Austrian Constitutional Court, necessarily as a political actor, recently introduced such things as same-sex marriage or assisted suicide and so on and so forth, and is a very important dynamic factor when it comes to political progress in Austria, and it has been in the past also, of course, been accused of being maybe too progressive, even in many cases. So if you were to interview members of the court or the president of the Austrian Constitutional Court, were they particularly fond of such an instrument, they would all say, nah, better leave it out, because it leaves us and our decision-making process a bit farther from public overall scrutiny. And it would, to some extent, or at least if I understood you correctly half an hour ago, also accommodate your argument that too much transparency must not necessarily be considered beneficial when it comes to things like that, because if the public is simply presented with a decision that appears to be unanimous because the court always and necessarily speaks per curiam in the Austrian case, this is simply the law, and it's not a matter of opinion, be it majority or dissenting opinion.
I think that that response is well taken, and it's hard for me to believe that the presence of dissenting opinions and the transparency of 7-6 over votes would not tend to create an impression, at least, of fallibility somewhere. The question is whether that price is worth it. You know, until, well, of course there have been controversial Supreme Court decisions. Brown was enormously controversial, as of course was Roe. But the Supreme Court managed to have this practice of minority opinions while maintaining substantial public support. Even to this day, the court is still respected. So it cannot be inevitable that the presence of minority opinions and tallying of votes undermines the court. I think, frankly, it might take the particular concatenation of bad luck that we have going in the United States right now to produce that effect. And in another context, it need not happen.
Mm-hmm. Okay, so let's come back to the question that I promised you that comes out of the audience. I was accompanied by a young scholar who is about to embark on a journey to the US in the very near future, pursuing his legal studies there. And I asked him, well, what question should I ask on scales? And he said, Professor, you got to ask him, well, who leaked the draft opinion? Yeah? And that is evidently something of common interest, because, I mean, when Roe v. Wade was decided, Roe v. Wade being the landmark case introducing the right to abortion, at least under certain circumstances, and within certain periods of time, against the backdrop of a right to privacy, which in and by itself is not explicitly written in the U.S. Constitution. So a highly controversial case at that time, decided by the Warren Burger Court, written by Warren Burger, I think itself, if my memory doesn't fail me.
No.
Wasn't it?
No, I was confused with Stevens. I'll come back to this.
But there was a strong dissent by, I think it was White, in Roe v. Wade, that the current draft opinion that has been leaked, it's written by Samuel Alito, builds on and does so rather heavily. So that's the development, as you explained it before, so minority opinion that may become, in the end, a majority opinion, or so at least this first draft is phrased. Nobody knows, of course, how the Supreme Court decision will come out eventually, because it is scheduled, I think, to be handed down at some point in June or so. So there still a lot of water would flow down the moor, as we would say here in Graz. It's a very important river to us here. We like our rivers. No, it's over there, actually. This development is somewhat, let's say, scary. In and by itself. The country politically is very divided at this specific moment. No matter how the Mississippi case that invites the court to reevaluate Roe will turn out eventually, there's going to be a massive political dispute that may well be dragged out in the open, and that for the first time ever, I think, in the court's history, a draft opinion has been leaked in order to evidently put pressure on the court to on the justices to side with one side or the other, is a very disturbing signal. So, coming back to the question of my young colleague, who do you think leaked it, and why, actually?
If only I knew, I'd be very rich. So certainly the first impression, seemingly almost universally shared, if for different reasons, was that it had to have been one of the clerks, possibly a justice, in the minority. And the rationale would appear to be, well, we need to shame this emerging majority into not going through with a reversal of Roe v. Wade. I personally think that is still the likeliest explanation. I think that the leaker is on that side. I'm not sure where the leaker is. It certainly has created, a sensation in the United States and galvanized the pro-choice movement. And yet, there are some problems with this theory. I mean, how many conservative Supreme Court justices are going to lose sleep at night because the New York Times is calling them dirty names? Not too many. Justice Kavanaugh knows a thing or two about protests, and again, while he's got a complex jurisprudence, do I think that some chalk outside his driveway is going to change his opinion? I don't. So understanding the mechanism by which this leak, if it came from the liberal side, understanding the mechanism is a little elusive. So perhaps it was someone on the other side. Here the theory is that there is a wavering conservative justice. And one of them, I mean, Justice Roberts was certainly, he's got some waver in him, but on this theory, by announcing prematurely the ruling, you make it impossible for someone to change his or her vote because it would so plainly be under duress. It would so plainly be as a result of the entirely expectable blowback from certain quarters. So would a conservative-leaning person have done this? I mean, I'm fairly conservative, and I can tell you that I don't care what the New York Times thinks of me. Not that they have any opinion of me. And I certainly have thinner skin than Justice Thomas or Gorsuch or Alito, to be sure, who cares about nobody as far as I can see. So that mechanism also it just doesn't quite add up. My first thought had been that someone in the printing office got to this and, again, probably from the liberal side, decided to leak it. There has been some reporting suggesting connections between the Politico reporters and some liberal justices, Supreme Court clerks. I'm sure the connections are there, and they are certainly suggestive, but they're not conclusive. And so the answer is I don't know.
Okay, well, it's a very credible answer.
For once.
Yeah. Thanks. We have a question in the first row. Daniel.
Thank you. Should I use that?
Yeah, you should use it.
Thank you very much.
Why should I hand it to you if you were not to use it?
Yes, because I don't think that you're using it. Anyway, thank you very much for the discussion so far. Very interesting. I have a follow-up question to your debate on dissenting opinions, because there is some interesting and also straightforward research on the psychology, in psychology, that people strive for recognition. And so what I'm wondering is, when you introduce or not introduce the ability to provide your dissenting opinion, you open up a forum for judges to present themselves publicly. And I'm just wondering what it makes a difference, what difference it makes for a judge if she can express her opinion, and therefore, whether she then is mostly striving for public recognition when she has the ability to do that. Otherwise, if she knows that whatever she says however she decides in that case, it will never be of anybody's interest what she personally did. So whether that might change the role that a judge feels herself to be in. Thank you so much.
Certainly. I do think that perhaps a combination of public recognition but also influence. So, although I don't think you have this example in mind, Justice Sotomayor, at the conclusion or during the arguments in the Dobbs case, the abortion case, she, seeing that things were certainly not trending in her direction, which would not have been a surprise to her, she said, I just hope that this court could survive the stench of politicization that would result if it were to reverse Roe. Now, what is she doing in that moment? I mean, one, must acknowledge she's venting some frustration, which anyone could do. Probably not a very effective tactic. You might have that conversation privately. I guarantee these conversations have been had privately among the justices. But again, I think that is very unlikely to have the desired effect if you do this in public. That said, I think that Sotomayor was also signaling to the public, to those elements that agree with her, that this is a very serious situation. You might want to think about that, public. And as someone who just argued in favor of minority opinions, dissenting opinions, I do find it unpleasant. It does reek of politics, not partisan politics in the traditional way, but certainly a close cousin of those. I'm still convinced that the ventilating benefits of having the views clearly expressed, even for posterity, make it worthwhile. But, as an example of something where I don't feel that way, back to my concerns about transparency, there are frequent, every year, there are questions about whether or not the Supreme Court should have cameras in the courtroom. It really the past 15, 20 years has it made audio recordings almost immediately available. The concern about having cameras in the courtroom is that the justices will act accordingly. They are humans. Scalia was a very, very animated guy. He would love it. He hated the idea. But if the camera was there, he would be the star of the show. I think that would be subtly corrosive of the institution. And it's not implausible to wonder if minority positions, which can perhaps be uttered to create a type of constituency, whether that might also be subtly corrosive. But as I said, perhaps Pollyannishly. I think it took a lot for the Supreme Court in the United States to get to where it is right now, and I just am not convinced that it's an inevitable process if we were to go that way.
Thank you.
Somebody else wants to go into the conversation. Two more questions. Ladies first, evidently. Mr. Gosh, let's collect 3 questions, maybe. Yes, you go first.
Okay, thank you. I just wanted to ask, with the prevalency of minor opinion, do you believe that it shows the public that a unanimous decision is not possible, and by that is causing an even bigger divide with political sides?
Of course, part of the problem is that so many opinions, one, they are, if not unanimous, overwhelmingly one side, but also would just not be of great interest to the public. Just a handful each year. And so, it's true the Pope would focus on the three they cared about. And it's also true that the three they cared about might be the ones that are most likely to reveal a fracture on the court. While members of the public do not have, in my view, very nuanced or sophisticated understanding of judicial method, I think they can appreciate that there are different approaches to the Constitution, to the task of a judge, and that judges can disagree. I mean, one thing which would, again, I need to know more about the structure of the Austrian system, but just doing a thought experiment, what if we were to eliminate minority opinions at the Supreme Court? And let's say we eliminated them across the federal judiciary. We have 1,000 district court judges, about 240 appellate federal judges, spread across 13 different circuits, collections of judges. There are disagreements between circuits all the time. There are disagreements between judges all the time. They live in different states, so they're not arguing, but the two opinions cannot have been written by the same person. Does this reality undermine public confidence in the law? I don't think so. I think one would really have to have we would say dismissively, a high school civics understanding of the judiciary to think that even within a particular approach, like originalism or something else, that there's exactly one and only one answer, and therefore, if they aren't agreeing, something's wrong.
Okay, sounds about right. Third row.
I've gone from persuasive to sounds about right. Maybe my next answer will be okay.
Right. So let me come back to this leaked opinion. So I read through it, or rather I read through a few pages that were leaked prominently on the political website. And to me, and obviously I'm not an expert in US Supreme Court decisions, but it read as a rather simple legal opinion, jumping rather quickly to conclusions and so on. So I would just be interested in your views, and maybe the question goes to both of you actually. If you compare Supreme Court decisions of the last years or of the last decades, do you see something like a decline in the quality of legal decisions corresponding to an increased politicization of the court, or was it just my layman's reading that actually the opinion is pretty much the same as other opinions were in the past? Thank you.
There are many who would argue that Roe was pretty simplistic and assumed away a lot of the interesting questions. In the law school, that's too complicated. When the public thinks about Roe v. Wade, of course, it has not read the decision. It's just the idea of the decision that people like or don't like. And so I think one can find unpersuasive decisions across the spectrum. Alito is, well, not the most elegant writer, a pretty smart guy who has marshaled, I think if you had the chance to look further, has marshaled a lot of the arguments about Roe v. Wade in a manner that is congruent with the way Alito and perhaps the other 4 or 5 justices would think about it. And so, with respect to that, everyone knows the handful of issues. No one's going to prove that the right to abortion is or is not in the Constitution. No one's going to do that. But I know for a fact that he alighted on some of the structural defects of Roe, which, to borrow a term that I used in the discussion that we had a couple of days ago, has deranged our politics. And so I do think that, I think the opinion is is fine in terms of its craft. And I also think that it's very hard to find an honest answer to that question, because so many professors and commentators in the media will bring their own priors to bear. I will answer your kind of broader question: has there been a decline or a change in the quality of Supreme Court opinions? It varies. I have seen Justice Ginsburg, very smart to be sure. There are times, about 15 years ago, I thought she's letting her clerks write these opinions. She just, she's a little tuned out right now. They're not wrong necessarily, but they aren't nuanced. They aren't persuasive. I think justices go through, good and bad stretches here. They're all pretty talented in different ways. While I might suggest that Supreme Court decisions, because of their stupefying length in recent decades, have become somewhat less readable. And because of the way the court makes decisions, frustrating to extract clear rules. I can't say this is different than anything. If I were to pick a volume from 50 years ago, I'd find a lot of really quite bad. I mean, that might be fine, the outcome. But I'd say, God, boy, they're just kind of painting the wall with this opinion. Justice Holmes, brilliant guy, who wrote very fast. He wasn't necessarily going to cite a lot of law for some of his opinions. Some of them stood the test of time, some didn't. So my answer is, I would not be concerned about the overall quality of Supreme Court opinions. There are times when I have concerns, particularly as an insurance professor, in how well judges who, generally speaking, did not take insurance law in law school, how well they understand what they're doing. But that's a particular concern. I wouldn't apply to judging generally.
And that would also, I would just like to emphasize what you said. I mean, it would depend on what you consider a well-crafted opinion in the first place. Yeah? Is it a matter of style? And I think we can agree that the current Supreme Court, maybe setting aside the Chief Justice, doesn't have that many talented stylists in its ranks at this very moment. So people like Holmes, for example, one of the great writers in the legal profession, they're not on the bench currently, and Alito certainly is not. However, the funny thing in the draft opinion that was leaked is, you mentioned that only in passing, is that Alito specifically, and if you skim through it, you would have read that, criticizes, it was Blackman.
Yes,
it was not Warrenberger, but Warrenberger joined Blackman's opinion. The particularly weak reasoning of Roe versus Wade, and it is a strange decision indeed. Yeah, and Alito picks on that. Starts exactly at some point in the Roman Empire, and then trying to make the case for privacy in the U.S. Constitution and the right right to abortion that is covered by it. So I think whether or not the reasoning actually can bear scrutiny is something that is subject to dispute, legitimate dispute, and something that is disputed at this very moment. However, and that is the most important, and I think the most interesting question to be discussed, that whether or not the weakness or the relative strength of the reasoning notwithstanding, the power of precedent should actually be so great that even a well-reasoned or better-reasoned case that is made a couple of decades later should be in a position to trump that. A leader would argue yes. Many on the other side, whether or not they like the actual outcome of Roe, would, for matters of principle, say no. And that is something that will certainly accompany this decision, no matter which way the chips fall. But we had another question in the second row here.
Thank you very much. Good evening. My name is Bernard. I'm from the Faculty of Law. I'm from the Department of Legal History, focusing on the questions of constitutional history. Many thanks in first hand to the Dean and to Professor Adams. It's a wonderful performance. I hope maybe it could be said over to this follow-up story here. Whatsoever, firstly, maybe I have a counter-argument regarding the elegance and beauty of the Austrian Constitution. The former Austrian Minister for Justice also said once in the 1970s, it's a ruin in every regard. So maybe just as an introduction. But to be serious, my point is, I argue that constitutional courts, the institution of constitutional courts, are bulwarks of rule of law and democracy. And we can witness in the United States since, quite some years, that the contrat social is actually eroding. There is a very tough polarization. We all know the situation in the States. And I'm interested how academics perceive the situation at the Constitutional Court regarding that the polarization which takes place in the American society, which takes place in politics on both sides of the aisle, is also meanwhile reflected at the Supreme Court. If we look to the appointment of the last judges, if we look at the things that happened in the last years, what do academics think that judges are clearly affiliated to a political party? What's the perception in academia in the United States on this part? And what's the take of academia in the States regarding the question that judges basically are carried out of the Supreme Court when they're dead? I mean, that's a system which we know from the Kremlin, certainly, but it's for me personally a bit odd that Justice Ginsburg, I don't know how old she was, at the end of her 80s, I don't know exactly when she passed away. So what's the take of academics in the States on these 2 points? And finally, what would maybe you, Dean, Bezemek say, what would Hans Kelsen say? When regarding the pure theory of law, what would he say if you have a justice at the Supreme Court, the Constitutional Court, which is clearly affiliated to a political party? Thank you very much.
Thank you. Wonderful question. You have to go first.
Yes. Well,
this is a much harder part to go first.
If I were a more careful individual who cared what some people, my colleagues, thought of me, and if I didn't have tenure, I might be reticent to answer this question. Fortunately, that timid fellow isn't here, so I'm happy to answer that question, but it might not be the answer that you anticipate. So academics are, without a doubt, leading the charge in the polarization of American politics. They certainly believe that they are speaking truth to power. They certainly believe that they, and perhaps they alone, are privy to intelligences and realities that elude simpler folk. They all happen to agree on matters of politics to a very large extent. And I think that they are unduly modest in their influence, as well as their own social station in our country. So they decry polarization without, I think, a very clear, realistic appraisal that they have helped to make that possible. They weren't the only actors involved, but there are rarely questions about where American academics are coming from politically. With respect to, so when they look at the court, absolutely, they increasingly subscribe to what I'll call the New York Times comment section view of the Supreme Court. 6 Republicans in black robes, and that's the only reason why they voted that way in Citizens United. And there can't be any explanation for overturning Roe v. Wade apart from the desire to reinstate theocratic patriarchy. I mean, there's no other explanation, plainly. This is the quality of discussion that we have in the United States. You asked a question about, if I understood towards the end, about very, very old justices. Ginsburg died in office, and that sequence of events has not been without consequence. Scalia died in office too. Those events were quite complex due to the politics of Washington, D.C., but a very consequential event. I believe that life tenure is a good idea for our justices. It would not be irrational to have a very long fixed period. People often say 18 years as a possibility, trying to kind of set up the staggering of terms. I think it's a little short, but 25 or 30 years, that's not crazy. That said, I do wish to insulate the court as much as I can from political considerations. And that means I have to hope that justices will pick the right time to retire. I mean, from perhaps my perspective, Justice Ginsburg should retire because, she was not the same woman that arrived on the court, in 1993. From others' perspective, she should retire because, well, you got to make room for a younger version of her to preserve Roe v. Wade and other things. That's not an illegitimate view, but it's not, for myself, I would rather not think about my team in answering these questions.
Well, the Austrian system is differently, evidently, also when it comes to that. Members of the Austrian Constitutional Court, they have their retirement age at 70 or so by the end of the year in which they turn 70. So it's a system we came, I think, overall quite to cherish. To answer your question, the pure theory couldn't care less, evidently. Hans Kelsen did care, indeed, and he did care so against the backdrop of his own professional career. As you know, he was a member of the Austrian Constitutional Court, or at least the variety that was enacted against the backdrop of the Constitutional Act of 1920. With the first structural reform of the Austrian Constitutional Court, he was kicked out of the Supreme Court, and the Social Democrats offered to reappoint him. And he refused to be reappointed because he didn't want to be perceived, or so the story goes officially. Background is somewhat different, but we're going to discuss that maybe outside our televised debate here. He refused to be perceived as a partisan player on the court. However, he did realize there is a scholarship written exactly in the 1920s on formalism in law that evidently it was a bedtime story, and that you would tell your citizens that the Constitutional Court was not a political actor. And he was very much opposed to the spin that what Constitutional Court justices would do was applying the law all the way down, deducing correct results from some abstract principles. That was not the job. And if you were to consider Kelsen's active tenure as a member of the Austrian Constitutional Court, you would perceive him as a rather activist member of the Austrian Constitutional Court, somebody who had his convictions and found his way to actually shape the court's case law in a certain direction. So Kelsen certainly perceived the Constitution also, however, certainly not exclusively, as a political instrument. That would, however, lead me to, because I promised my guest dinner later. That would lead me to a final question, because it brings me to the idea of whether or not entities such as the Constitutional Court in Austria in the 1920s, for example, or the Supreme Court should be subject to reforms. I mean, the American Supreme Court has been reformed rather often in its history, even though, of course, that is something that is not debated publicly. So the 9 are, given the history of the court, a rather recent development. Hasn't been 9 ever since the beginning of the court, and the way the court, circuit riding and so on and so forth, functioned changed significantly over its existence. In the 20th century, famously, it was Franklin Roosevelt who threatened to pack the court and make room for more favorable decisions towards his New Deal policy. And Joe Biden, famously or infamously, depending on the perspective, he set up a commission on Supreme Court reform, and this commission that was composed of various experts, political actors, and so on and so forth, handed down recommendations only recently. Biden evidently is politically not in a position to actually reform or pack the court, but if he was, would you recommend he does? Is the Supreme Court in need of reform?
I would definitely not make that recommendation. And one of the reasons is that, you know, one of my colleagues was on that commission. I think there are very few people in the United States who would support these reforms who would not, in a private chat you might have with them, acknowledge that they are solely instrumental. Nobody in the United States is arguing that 15 is inherently a better number than 9. 9 did not come down on stone tablets, as you point out. It could have been 15. It's been 9 for a while. The only reason to move it to 12 or 15 is to get the right additional 3 or 6 justices. I think this would be catastrophic with respect to the idea of, you say fairy tale, children's story, what was that?
Bedtime story.
Bedtime story. I like bedtime stories.
Everybody likes bedtime stories because they make you sleep well.
Exactly. Yeah. And I do think that at least some bedtime story is important for institutions to function. Even apart from that, we have basically come to an understanding of how the Supreme Court works, given its composition and traditions. One of the reasons why I do not favor term limits, or certainly an expansion, is that I do not know how that will work. And while certainly it is not working, nothing is working perfectly right now, it's working better than the other branches of government. And somebody would have to articulate a very clear argument for why this or that structural reform was inherently better, as opposed to inherently better for as long as I have 50+1 votes in the Senate. Trust me, after November, the Senate might say it might change, the House will probably change, but nothing is certain. But if the composition of Congress were to change, you would not hear a word about this. Not just because, of course, Biden will get his own ideas, but because the people who are now suggesting urging we must have this reform would find the urgency greatly attenuated if those reforms were going to be wielded to put another 6 Republican nominees on the court. So no, my counsel to President Biden, who does not seek my counsel often.
It's his bad, evidently.
look, I'm doing what I can for the man.
So let me say this at the end of our discussion, as you of course wanted me to, and it is rightly deserved. This was a very nuanced and of course correct answer to the question. And let me say thank you. Thank you so much for being with us tonight. Thank you so much for answering our questions and having this wonderful discussion with us. And let me thank you, ladies and gentlemen, in the audience for joining us tonight for our Dean's talk on the US Supreme Court, Power, Politics, Beauty and Elegance. Adam, it was fabulous having you.
It was a pleasure speaking with you.